hearing is in the matter CA-006 of 2020 before the Chief Justice Zaki Azmi, Justice Wayne Martin and His Excellency Justice Ali Madhani, and is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the Registry in Dubai on the appeal bench's instructions. The appellant is represented by King & Wood Mallesons. Lead counsel is Vernon Flynn QC, assisted by Tim Taylor QC. The respondent is represented by DLA Piper Middle East. Lead counsel is Tom Montague Smith QC.
Yes, we noticed that there is an application filed for some amendment to the grounds of appeal. Is there any objection from the respondent?
Yes, there is, yes.
So do you want to go with the application for the amendment first?
Well, Chief Justice, I wonder if I could, what I was intending to do was just give the court an overview of the context of the appeal and essentially what it is we say and why. And I think in order to make my application, I'd need to explain what it is we say. And then the court could deal with the opposition to the application if that's appropriate. We've got three grounds which I have proposed, which weren't in the original grounds.
Yes, as I understand it, Your Honour, there's an application to amend the grounds. There's also an application to file a supplementary skeleton argument as well. So there are strictly two parts to the application. And they're both opposed. It makes sense to me for that to go first.
Just a matter of thought. Would Mr. Montague Smith be ready to proceed on with the appeal? Should we allow this application to amend?
Not on the new grounds, no. There's no submissions from me. The application to amend came in on Tuesday afternoon. So it's made 2 clear days ago. I don't know whether it was made before 4 p.m. If it was made after 4 p.m, then it's 1 clear day ago. So actually, this is in effect an ex parte application. And my friend really ought to be complying with his duty of full and frank disclosure. But no, it raises a series of new points. None of them were raised below either. And so there are some... And it raised, I'll explain as I respond to his application, but they raised some fairly controversial issues of law, quite apart from the issues of fact that they raised. So no, I have to say, it's quite clear that it wouldn't be possible for me to reply properly.
Okay, let's hear Mr. Flynn from
Yes.
On your application first.
Yes. Can I say a little bit about the context, though, so that I can explain what points it is we're taking? The first point is that the appeal concerns a valuable undeveloped plot of land in the DIFC, which was owned by my clients. It was subject to a mortgage in favour of Emirates NBD Bank. And as you know, ENBD applied as mortgagee for 2 packages of relief in respect of the plot. Firstly, they asked for the sale of the property within 18 months, or alternatively, they asked for foreclosure, so as to put the title of the property into the name of ENBD and to take any equity of redemption for themselves. And those were put forward as Part 8 claims, and they were said to be simple debt claims. Now, the first package was rejected by the judge, but foreclosure was granted absolutely. And as you know, my clients weren't permitted to have any legal representation, and the judge refused an adjournment of a month as requested, or even a week, to obtain legal representation. That was because the judge said the application was a spoiling application in the hope of deferring and prejudicing its outcome, and he said that no defence was identified. Now, the first point is that given there was no prospect of the sale of the property for 18 months, there was no urgency in that respect, and no defence was identified because the judge refused my client time to obtain the necessary legal advice. Now, to put the appeal in context, it's our case that foreclosure is an extreme and rare remedy. It is extreme because it has the effect of transferring title and thus any equity of redemption to a lender. Now in England, it was said to have been rare as long ago as 1993, and the Law Commission in England has recommended its abolition. So orders for foreclosure in our submission should be approached with some caution, and there are well-established necessary requirements and safeguards before an order for foreclosure can properly be made, and our application to amend is in that respect. And the reason we say that is no order for foreclosure should have been made without joining any interested third parties. That is a substantive rule, and the judge was aware of the interests of the Abu Dhabi Central Bank as a mortgagee, but he nevertheless made an order absolute for foreclosure contrary to their interests. So in other words, this appeal isn't just about the interests of my client directly, it's also about the proper approach in relation to interested third parties. So even if foreclosure was appropriate, and even if there were no third party interests, which isn't the case here, then the borrower is given 6 months to pay under an order nisi. So the way in which it is done is that if foreclosure is appropriate, there is an order nisi allowing the borrower 6 months in which to pay. And that, in our submission, is the very most that the judge ought to have done. That's the other aspect of our amendment. So that the judge shouldn't have ordered foreclosure absolutely at all. He shouldn't have done so in circumstances where there was clearly a third-party interest without joining that third-party interest, and he shouldn't have done so without making an order nisi giving time for the borrower to pay. And as a consequence of the refusal to allow time to obtain legal advice, my clients were unable to make any submissions on the substance of the claim or to raise the arguments that we now raise in relation to foreclosure. And as we say, the remedy is exceptional. And that is why we say, in essence, why the judge got it wrong, both as a matter of law, since submissions weren't made on the point, and in order to allow foreclosure to be dealt with on proper principles and as a matter of fairness. Now, with that introduction, I'll take you to our application to amend for permission to appeal.
Before that, there was why did you file this application such such a late hour? I think that is an issue with Mr. Montague Smith also raised, and to me, you have to overcome that threshold first before you go on to the substance, so-called substance part of the application. Why was the delay and things like that?
The answer, Chief Justice, is that I was only instructed very late, and I made the application as soon as I was instructed, and that is the reason why it came in late.
Is that a good ground? Is that a good ground for granting application at such a late? The fact that the council is you were appointed so late in the hour, is that a good ground for us to grant the postponement, or rather the amendment?
Chief Justice, I would submit that it is, and the reason I say that is this: that this is a very substantial claim. It's not a small claim at all. I think the mortgage is about over $50 million US.
I appreciate that. But what was the reason why your client engaged you so late?
Well, I wish they had.
I want to know why did you accept this brief when you were briefed so late in the hour?
The answer, Chief Justice, is really quite simple, and that is because the points are so important and they're so fundamental to the appeal. And they are, in fact, very straightforward points of law. This is not a case in which we're asking to adduce factual evidence that would have made a difference. This is a case in which we submit an injustice has been done to my clients because such an extreme remedy has been granted. And so the points that we take on the amendment are very, in a sense, straightforward points of law in our submission. Nothing I've said or indicated is in any way unusual or in any way in my submission really very controversial. These are all points that are standard practice. And so in those circumstances,
but is it normal even in England for adjournment to be allowed, or rather application for amendment made last on the grounds that the council was engaged late? Is it a ground for allowing this sort of thing? I'm not sure. I'm not sure the practice in England.
I think, Chief Justice, the answer is, if it raised, I could understand there would be an objection if it raised points of fact. In other words, points that could have been dealt with as a fact below but weren't. But these are pure points of law. We've put in the cases, we've made our position very clear, we've adduced our material. It's not a case in which it requires any issues of fact. So the fact that it's late in my submission is neither here nor there. The points are very straightforward and simple, and if there is an answer to them, they can be put forward in a very short order. I mean, your Chief Justice, you'll also know that my clients have paid the security in order to bring the appeal here. So as part of their application, they have satisfied the tests, the requirements of the court in order to enable them to bring the case. If put it this way, in my submission, it would heap injustice upon injustice not to permit my clients to raise these particular issues of law. They're very important for the jurisdiction as well as my clients.
I think all of us are sympathetic with your client. You know,
yeah.
They had acted, appeared in person, you know, without representation, and then they were ordered to pay security for costs, which they did, I think, at the last minute also. We are sympathetic with them. I'm speaking strictly from the point of view of the law and the procedure and the practice, legal practice, law practice. That's all I want to know.
Yeah,
you know, in Malaysia, it depends on a lot of circumstances. It's not so straightforward that we grant or we don't grant. You know, you look at all the surrounding circumstances, and I think that's what you are trying to do as well, to bring to our attention that this is not justice. You know, justice in the broad sense that if we are reading the procedural law too strictly against your client, I think that's what you're trying to say.
Yes, I do submit that in the context of this case, where the original application and the original complaint of my client is not to have any time to instruct lawyers and help the court with the proper approach to the application, in my submission, it would compound that injustice not to permit the amendment to be made and the points of law to be taken. In my submission, it's important not just for my client, but also for third parties and also for the jurisdiction itself to have some principles as to how an application for foreclosure should be approached. In England, it's a matter of discretion as to whether or not it's permitted. But in my submission, in circumstances where there are no new facts, these are points of law, in my submission, that is a very strong factor as to why permission should be granted.
Mr. Montague, do you want to reply this point now, or shall we allow Mr. Vernon Flynn to proceed on with all his other submission, and then you can reply all at one go, Mr. Montague?
Well, Your Honour, I think we need to decide the application that's being made first, because then then we know what we're arguing about. And I think that, you know, I'm just not in a position to give you a full response to these recent submissions that have been made. My learned friend says these are terribly important issues for the development of the law in the jurisdiction, but that is not a reason to deal with these sorts of issues in this way, which is on the basis of one-sided submissions. Your Honour's being told a number of things which are said not to be controversial. They are controversial. It's simply not correct to say that it's a straightforward matter of law. that under the Torrens system, foreclosure requires an order nisi, and then to be followed by an order absolute, and that's all the way through my learned friend's submissions, and he says, well, it would be a novel remedy to do it without an order nisi, and that's simply not accurate. I'm not in a position to show you how that goes. And I think Your Honour does need to. The other thing is, my learned friend keeps saying there are no issues of fact. There are issues of fact. There is new evidence that my learned friend relies on, which wasn't produced below. And the other point I'd like Your Honour just to have in mind is that, you know, this is rather presented as though a young lady attended on behalf of her elderly father, who was a litigant in person, and made submissions about the family home. The appellant is a multinational, part of a multinational group, which deals in things like construction, infrastructure, and so forth. It has 30,000 employees, according to its own evidence. And Miss Al-Jabir, who represented at the last hearing, was the chief operating officer of the company. It has in-house legal capability. So that this impression that you're being given is just not a fair one. Your Honor, I can answer the application if you'd like me to. You asked the question, should I answer the application?
Yeah.
I don't think Mr. Flynn's fully developed the application yet, though, has he?
I don't think so.
But I must say, I think it would be sensible if we heard Mr. Flynn in full in support of the application, and then if we heard from you, Mr. Montague-Smith.
I agree. Thank you.
I was about to say that. I was about to say a thing. I think we allow Mr. Justice Ali. Do you agree, Judge Ali, that we'll hear Mr. Flynn to the end, and then we allow Mr. Montague to reply on both issues, on the application as well as
that makes sense.
That makes sense.
Yeah.
I've not understood that was Justice Martin's suggestion, but because I'd understood.
I think Chief Justice was referring to the application to amend the grounds of appeal and deduce the skeleton. Those are the two topics.
But not to develop the grounds themselves. Yes.
No, not to develop the other grounds.
No, that will be later.
Thank you.
Yes. Yeah. Okay, Mr. Flynn, just go ahead with what you're submitting.
I'm grateful. I should just say one thing, that my learned friend says he needs time to deal with the submissions. We did yesterday get a number of authorities in response to our application. So I was expecting him to say that if permission were granted, he could deal with it. But if he says he can't, then obviously I'll take that at face value. Can I first take you to our notice, which is bundle 2, tab 5, document 1 at page 1859, and you'll see.
Are you going to display that on the screen? No.
Yes, I've.
Is that possible for you to do that?
Yes, I've tried to do the direction to. How do I? Well, I'm not sure how I put that up on screen though. On Skype for Business, it doesn't. I'm not sure one can screen share in the same way.
Okay, never mind.
If you your direction to the page has worked on my system, so I'm at the page.
Okay. I'm grateful.
Yes.
Thank you. And you'll see under that application, we asked for permission under the Rule 44.93 to append the application notice to add new grounds of appeal, to extend time to adduce the supplemental appeal skeleton, that's my skeleton under my name, of the 16th of November, where we set out in full our submissions on the grounds, and then an application to serve the application notice on short notice. And if you go on to page 1860, you'll see the grounds set out there from paragraph 1 onwards. Now, in summary, what we say is that the amended grounds ought to be permitted because all 3 of the new grounds are all pure points of law, which do not necessitate new evidence or new fact-finding. We have referred to evidence of valuations which came into existence after the 15th of June 2020 order, but that only serves to underline the prejudice to ADCB and isn't determinative of the appeal. The core of our argument on appeal is that the judge failed to apply the safeguards which apply to an order of foreclosure and failed to take into account relevant considerations which were before him in the 4th of June hearing. Again, those don't require factual inquiry. The second point we make is that counsel are newly instructed to the matter and instructed subsequent to the order of the Chief Justice granting permission to appeal following the original appeal notice. And thirdly, we say the proposed appeal has a real prospect of success for all the reasons that we've given. Now, there is a compelling reason also why the appeal should be heard on grounds 5 and 6 relating to foreclosure, and that is because the legal principles applicable to orders for foreclosure have not previously come under consideration in the DIFC courts. One of the points we make is that the judge misunderstood the consequence of the torrent system. And so not only is it my client's interests that are involved here, it is a third party's interests and indeed the interests of other litigants in the future. And we do say that as a result, this area of law will be greatly benefited from judicial consideration by this court. Fifth point we make is that decisions relating to foreclosure have the potential to cause prejudice to third parties because their security interests are liable to be foreclosed without adequate safeguards. It's our case that on the facts, the order of the 15th of June did in fact cause prejudice to Abu Dhabi Central Bank. And that's an additional compelling reason to allow the appeal and also to reconsider the correct approach generally in this area of law. Now, I have to accept...
Mr. Flynn, sorry if you interrupt. Yes. If the amendment were allowed and the matter were adjourned, as I think Mr. Montague-Smith has foreshadowed, would it be appropriate to join the Abu Dhabi Central Bank as a party to the appeal?
Yes, they have real interest here. That would be a sensible approach. Our case is that they have their own interests and they can advance them on their own through their own counsel. I don't object. I don't have any.
Well, have there been any communications with the Abu Dhabi Central Bank? Do you know where they stand in relation to this? I know they were given notice of the proceedings at first instance. Yeah.
That's right, they were.
But they didn't participate, and you can understand that because on the face of the proceedings at first instance, there was an application. There were two applications. One was for sale, and the other was for foreclosure. And as a subsequent secured creditor, they would have expected, I suppose, the application for the sale to proceed, and their interests as secured creditor to be protected in the course of the sale process. And I suppose the foreclosure may have come as a surprise to them as well.
Yeah.
But we don't. Do we know anything about their attitude since they were given notice of the proceedings back in May?
There is one thing I should tell you, the court as well, which is an important development, which is that just before the hearing, just before this hearing, a third-party purchaser called Omniat reached an agreement with my clients to purchase the property, subject to contract and subject to EMBD's consent. And Omniat has offered to discharge the monies owed to the Emirates bank secured on the property. Now, that's obviously an important development because it could potentially have serious consequences for other parties. In other words, what's happened is ENBD have the opportunity to be repaid the debt that's secured by the mortgage because the offer involves a discharge of the debt from the sale proceeds. Now that, but then Abu Dhabi,
well, that reinforces, I think, Mr. Flynn, the desirability of perhaps having the other secured creditor before the court as well, because they might prefer the respondent to be selling the property as secured creditor, generating enough proceeds for them to be paid out as well, rather than your client doing a deal that might leave it out in the wings.
Yes, yes, certainly, Judge Martin. I think it would be sensible to give the ADCB the opportunity to attend. Yes. I wouldn't say necessarily joinder. They can say that actually that it's not. They don't wish to attend. But I do think that I can't really think of any objection to that. I should also say that if the court accepts that Mr. Montague-Smith needs time to develop his submissions in relation to Torrens, I can't really oppose that. I appreciate the time is short, but if he does need time, I mean, these are very important points for the jurisdiction. I think it's very important that in other cases, litigants know what the position is in relation to foreclosure. And it's important that the court deals with it on the basis of full submissions.
Well, Mr. Flynn, my present attitude, of course, I don't speak for the other members of the court. My present attitude is if the adjournment is allowed, if the amendment is allowed, it would have to be on the basis that the costs thrown away by reason of any adjournment would have to be borne by your client, which would be the usual order of a late application of this kind.
Of course, Mr. Flynn. I expect your answer is of course, my lord. Of course, you have to bear the cost. You cannot deny the, your obligation, your client's obligation to bear the cost.
Can I say in relation to that? I totally understand that suggestion. The only thing I would suggest though is that in fact what you should order is for the costs to be reserved. And the reason I say that is this. Given your indication, it may be that on a renewed hearing you'd reach the same view that my clients ought to pay that. But there have been very rapid developments, not least this offer. And
this offer you are referring to, how serious is the offer? How serious is it?
It's a full and proper offer. I'm afraid it's not in the bundle because it's only been received so late. The reason I say reserved costs is because the court can do as it wishes on the renewed hearing, but you may take the view that the position of Emirates NDB is unreasonable in the circumstances of such an offer. Their interest is being repaid the debt. They've been made the offer. It's obviously subject to their consent. You might reach the view that the refusal to consent was unreasonable. And in those circumstances, that would inform your approach to today, because we wouldn't have been needed to be here today if it had been accepted. So
well, the problem I have with that, Mr. Flynn, is that the reason, if the case is adjourned, the reason for it will not be the offer. The reason for it will be the amendments to the grounds of appeal. And lawyers, your instructing solicitors were engaged by the latter part of June, which is 6 months ago. And so there's been plenty of time for the grounds of appeal to be revised and amended since then. And so I would have thought the ordinary rule, that is, if there's a late amendment that causes an adjournment, costs thrown away are paid by the party seeking the indulgence of the court, would apply. But I just speak for myself. No doubt we can hear from Mr. Montague-Smith on that subject in due course.
Yes, I mean, I would simply repeat what I say. You may take, the court may take the view, if we come back before you, that although the amendment could have been made earlier, nevertheless, this hearing was actually unnecessary completely because the offer was there and it was a perfectly reasonable offer and there was no good reason not to accept it. And therefore, there would have been no hearing and no costs thrown away. Now, that is a possible outcome. I totally appreciate Judge Martin's point that you may end up taking the same view that costs were thrown away, but I do simply submit that, in fact, you don't lose anything by reserving the cost with that indication. And we come back before the court, and then the court can decide the allocation of costs in the light of all the circumstances. That was all I was going to say on the application, though, so I'm happy to... unless you had any questions.
So, Mr. Montague-Smith?
Thank you, Your Honour. Just to preface it by this fact, which is that in the background to all of this, the appellant is still continuing to pursue proceedings in the Dubai courts. And so the degree of urgency which the respondent perceives exists is that there are competing attempts to have a collateral attack on this court's proceedings by pursuing an application in the Dubai courts. That application, it is said, is intended to lead to arbitration proceedings. My learned friend doesn't apply for an adjournment, but if we get to that point, that is the real reason why my clients have been seeking to get this appeal on for many months now. This is the appellant's own appeal, and yet it has taken steps at every turn to try to put this appeal off. It sought a stay at the outset. It tried to get another stay in support of mediation. That was refused. You will recall at the time the respondent applied to expedite the appeal, but that rather fell by the wayside because of the way in which the listing developed. And so this court's order at the end of the last hearing was that the appeal ought to be put on as soon as it practically could be. And then there was also an issue about even listing of this appeal. It's said by my learned friend he filed his submissions as soon as he was instructed, but still on the 3rd of November, that he was identified as the counsel who was to be instructed on this day. Sorry, at this hearing. So that's 2 weeks before the submissions were filed. We're told Mr. Vernon Flynn will be appearing, and by the way, he's not available for the window that the court was proposing. And then ultimately it turned out that he was available, but only on this day. So if we get to questions of adjournment, I'd ask this court to think long and hard about whether or not it's really appropriate to allow parties to conduct themselves in this way, in this sort of fait accompli, because in a sense that's what this case is all about. It's simply about, can parties just turn up and say, actually, we've created a situation which means that in order to do justice to us, you have to adjourn, and then the court just simply has to fall into line, or as I will urge your honours you ought to do, should this court impose a bit of discipline over litigants and take a principled approach to these sorts of issues. There is no application at the moment to adduce fresh evidence. So just make that also as a preliminary point. And despite this, my learned friend seeks to introduce it by just talking about it. Offers that have been received, valuations that he says have been produced. And that's almost doubly bad, because when you actually look at those documents, if you do get to look at those documents, you can see that they don't quite give the impression that my learned friend would want you to take from them. And it's certainly not accepted that there is any kind of windfall that arose out of the forfeiture. It is not accepted that there is an offer on the table simply for someone to produce cash to my clients that would pay them out for the loan and the interest that there was. And importantly, because I know that this is where there was questioning of my learned friend from the bench, it is absolutely not accepted that Abu Dhabi Commercial Bank, it's not the central bank, it's Abu Dhabi Commercial Bank, has a second mortgage in favour of this property. My learned friend presents that as an undisputed fact. There is no evidence whatsoever that Abu Dhabi Commercial Bank has a mortgage, registered or unregistered, in relation to this property. If there was such a mortgage, the appellant would be able to produce it, because it would have to be a contractual agreement between the appellant and Abu Dhabi Commercial Bank. But there is no evidence whatsoever, and it's never previously been suggested until Tuesday, well, the submissions came in on Monday, that there was a mortgage in favour of Abu Dhabi Commercial Bank. All the judgment said was that Emirates MBD consented to Abu Dhabi Commercial Bank having a mortgage, but none was ever, as far as we are aware, created, and there's no evidence that one was. And certainly nothing was registered. In relation to raising new points that are not argued below, the introduction of those sorts of points is the subject of many well-known legal decisions. The issue is not simply, are there material issues of fact at play? The issues were summarised, and my own friend referred to the fact that I produced some authorities yesterday. Those were authorities directed at this application, not at the grounds of appeal. So the principles by which a court of appeal will consider whether new issues can be raised on appeal were summarised in the Singh and Das decision. I can take you to it, or I can just tell you what it says. But that simply says, firstly, the court will be cautious about allowing new points on appeal. The court will not permit a new point to be raised if it would necessitate new evidence. It will not permit a new point to be raised if it would have resulted in the trial being run differently. Even if it can be shown that this is quote.
Smith, those points have been established in a context in which there was no suggestion of a denial of the opportunity to run the case below. One of the grounds of appeal here involves the proposition that the trial below miscarried because of the refusal of the adjournment.
Well, that's fine. Then
in other words, this wasn't as if there was a studied and informed forensic decision not to run a point or reduce evidence. The appellant's case is that they should have been granted the adjournment and weren't.
But right,
and so that the principles would have to be modified in that context, wouldn't they?
Well, perhaps, but you would be looking at that appeal, that ground of appeal being directed at the decision not to adjourn. Once if you consider that and accept the appeal on that basis, accept that it should have been adjourned, then fine, you can go on and decide what the consequences of that are. But if you reject that, if you decide actually the judge, as I say you should, simply took the right decision, there was nothing else for him to do. There was no defence being advanced. They'd had 6 weeks to prepare themselves. They presented him with a fait accompli and couldn't say what the defence even was. If you accept that position, well, then the next question is, well, then that part of the appeal is rejected, and you will be accepting that the judge did the right thing and heard the case. At which point, then it doesn't follow.
The new grounds of appeal, it seems to me, are related to that ground of appeal because one of the propositions I think that's put against that ground of appeal, a denial of the adjournment, is, well, nothing would have changed. If an adjournment had been granted, there was no defence. But the point that the new grounds raise is, well, yes, something might well have changed because it might have been pointed out that there were other secured creditors who should be made party to the proceedings, and I know that's an area of factual controversy. But it was said it would also have been possible for a lawyer to have come along and put the submission, and I know you contest this as well, but at least put the submission that the proper course would be to make an order nisi, followed by an order absolute in 6 months' time. Now, those are the sorts of things that were not put to the court because of the refusal of the adjournment.
But that sort of position couldn't have been right, though, because you're dealing with a situation where the mortgage expired on the 30th of June.
Well, that's another point. You see, everybody below seems to have operated on the assumption that the expiry of the mortgage meant that the rights all disappeared. And I struggle with that. But first of all, I must say, in a long time in the law, I've never come across a mortgage that expires on a certain date. Mortgages usually last until such time as the debt is repaid. But let's put that to one side. But I would have thought, and I haven't looked at this mortgage, and I don't think there's any particular reference to its terms in the judgment, but wouldn't there be a credible argument that rights accrued under the mortgage as at the 30th of June would remain in force even though the mortgage itself expires?
Well, it's difficult to see how that could be right, because when you look at the real property law, the rights to obtain an order for foreclosure accrue only to a mortgagee. And so the only a mortgagee can obtain an order for foreclosure. That is it. And so once you're no longer a mortgagee, then there is you don't qualify. And that's Article 63 of the real property law. It just doesn't work. Now, you're right. You're as right that from a common law perspective, it's unusual to have a mortgage that expires. I understand that is common practice within the locality in the UE outside of the DIFC. But the effect of it is, and I've not heard anything from the other side to suggest otherwise, that you stop being a mortgagee as at the date of expiry.
But then the consequence of that is, well, let's assume that's right, and you're certainly right. Respondent takes no point about that. But then you've been talking to us about the terrible problems caused by delay on the other side. What's happened is that your client, knowing that the mortgage is about to expire, has gone right up to the date of expiry and put itself in a position where it was simply impractical to exercise the power of sale, and then said, well, because we can't exercise the power of sale, you must foreclose, because that's the only right left to us. Now, foreclosure is an exceptional remedy. And you would then say, well, why would the court impose an exceptional remedy simply because the secured creditor has sat on its hands and not exercised the most appropriate remedy, which is the exercise of the power of sale?
Well, firstly, I wouldn't accept that it's an exceptional remedy. I've
never seen, in 50 years in the law, I've never seen it before, Mr. Montague-Smith.
Well, it's an out-of-court remedy that's available. It's very unusual that it is used, and particularly in English law context, which is what my learned friend refers to. But there are reasons for that, and largely the reasons for that are, and I explained them below in my skeleton argument. Largely the reasons for that is that there are better options available, firstly, and secondly, that in the field of consumer law, it's surrounded by protections for the consumer. And so it's just not relied on, because you can get better things more easily from the perspective of a bank than you can using the power of sale. But the question Your Honour's the point Your Honour's making is, well, why is it right not to give another 6 months when the need for urgency arises because of the timing of the claim? And Your Honour will have seen all of the evidence about the circumstances in which this dispute, how it developed. So the notice was given in January of 2020, and then there were discussions between Emirates MBD and Al Rihab, during which Al Rihab said on numerous occasions, hold on, we've got a proposal for you. We've got a proposal for you. I'm sorry, I've lost you.
There was default as early as 2016?
There was default as early as 2016. The date for
continuing state of default from 2016 right up to 2020. That's right, isn't it?
Yeah, so no capital was repaid from about January 2016. No interest was repaid from about the middle of 2017. That is correct. But there were specific discussions between the parties during which Al Rihab said to Emirates MBD, wait, don't issue, and we will then apply, we'll come up with a proposal. There were promises. The judge heard about all of that, and if the point had been taken, there would have been further evidence about further discussions that predated the January notice as well. The judge heard all of that and took a decision on the basis of the evidence that he heard, and he heard directly from Ms. Fatima Al-Jabir, who, as I say, is the chief operating officer of that company, he came to a conclusion now, which was that that in effect the respondent had been strung along by the appellant in a way which made it unlikely that the application for an adjournment was a genuine one. Now, in that context, can this court really wade into that debate? But that's not the ground of appeal. And when one looks at actually what are the grounds of appeal in this case, they're quite narrow, unless you expand them out in the way that's being suggested. But Your Honour, one of the the point that I was going to make is that it's right that when you raise new points of law, new issues on appeal, you have to look at this question of whether new facts are being developed. But the final element of the test, which is explained in the Singh and Das case, is that even if there is a pure point of law, it will only be allowed to be run if the other party has an adequate opportunity to deal with it. And that is the issue here today in my submission. When you're dealing with an application to extend time for filing submissions, that is treated as an application, it's dealt with on the same basis as an application for relief from sanctions. It's not an application of that sort, but it's analogous to that. And that's the other case that I provided Your Honours with, which is the Hisaj case. So where you're looking to get a retrospective extension of time for that sort of thing, particularly in the context of appeals, then the Denton principles, the principles from the case in England, Denton, apply. And you have to look at this three-stage test. What's the significance and seriousness of the breach? Is there a good reason for it? And then you look at all the circumstances of the case. And the more significant the breach, the more there will be need for a good reason, and the consequences of the breach are important. And if the consequences are that the respondent will not have a real opportunity to deal with them, then that will normally be fatal. And in the context of that case, Hissage, the Court of Appeal said, in England at least, that litigants in person are expected also to follow the rules. And they referred to the prospects that if they're not held to those rules, then there will be a free-for-all. And that is effectively what is happening here. You've got 1 or 2 clear days before the hearing, a last-minute application is made to expand and change the appeal, which is now looking like it's threatening the appeal date, which is a consequence that the appellant has been seeking to achieve throughout. And if you go and try and apply that Denton test to this situation, no good reason at all is given for these developments. The reason is simply that new counsel have come up with some new points, and as the Chief Justice has indicated, that is not a good reason. The respondent, the appellant, has had very experienced representation throughout. So very full written submissions have been made 6 months ago by leading counsel. And so we had a 16-page skeleton argument for the appeal. And in support of the service point, there's this issue about the constitutionality of the DIFC's rules on this. There's another 28 pages of dense legal argument. It can't be said that the appellant has been without considered legal input on this point, and yet we've got this 11th hour application just 2 clear days before the hearing. And I've mentioned that there have been prior attempts to delay this hearing. So the concern, as I say, is that this court is simply being presented with a fait accompli. And we would say that is consistent with the way in which the appellant has approached the case below. My own friend doesn't actually apply for a hearing, but as I've said, in a sense, this whole case is about whether or not this court can and should impose some sort of discipline over its litigants. And as to whether I can respond, it seems to me that it's just not possible to respond today. We've been presented with another 19 pages of new argument, and it's said that those are pure points of law, and I disagree with that. But even if that was right, we just haven't had time to deal with them. And you can't deal with them on the fly simply on the basis of one-sided submissions. You would just have to adjourn. In relation, just dealing very briefly with the three new grounds and then the additional further grounds. So you've got this first argument that Abu Dhabi Commercial Bank should have been made party to the proceedings. Now, what standing the appellant has to make that argument is not explained. You may have seen Abu Dhabi Commercial Bank was the restructuring agent for the restructuring that took place in 2014. So it doesn't have a commercial interest. It operates for the rest of the lenders. And it's been aware of these proceedings throughout. The respondent was obliged. Yes.
So on the question of standing, the effect of if there are, and I know you contest the fact that there are other secured creditors out there, but if there are other secured creditors with an interest in this land, they have lost their security by reason of the forfeiture order, and your client would get the entire property. Now that then has an adverse impact upon Mr. Flynn's client, because that means there are more creditors out there who are unsatisfied. So he has an interest in the creditors being satisfied out of the secured property, doesn't he?
Well, if there are other secured creditors out there, yes. Yeah. Sorry, if there are other unsecured.
Well, you just raised the point of standing, and I'm just putting the proposition. I can't see that goes anywhere, because if there are other secured creditors out there, then he has an interest in them being satisfied.
Well, because the effect of foreclosure. So, say you have unregistered mortgage out there, say that had an effect in law in the DIFC. It doesn't, and we can look at that briefly. But there's no question that there was no registered mortgage against the property. So the argument is A, there's an unregistered mortgage, and B, that an unregistered mortgage gives them an interest in the property, and C, as a result of foreclosure, then Abu Dhabi Commercial Bank's interest would be prejudiced. Now, each of those propositions is impossible to understand. A, if there was an unregistered mortgage, my learned friend would be able to show it to you. He'd be able to produce it, because his client would have given that mortgage to Abu Dhabi Commercial Bank. And no one has ever suggested until Monday that document existed, and they don't suggest it by reference to any kind of document. They just
well, the judge seems to have assumed in paragraph 23 of his decision that there had been a mortgage. He refers, you're right, that he only refers to your client having consented to
Yes.
a mortgage. But he seems to have proceeded on the assumption that there was in fact such a mortgage, which is why he talks about service on Abu Dhabi, service of notice on the Abu Dhabi Commercial Bank.
All he's doing there is replicating part of the witness statement of Mr. Jeet Wadwani, who had said that in terms by reference to a document, which was, I believe it was in the intercreditor deed, which said that my client gave permission to register a mortgage against the land to the restructuring agent. That's wholly conventional in restructuring, because what it does is it clears the path for the restructuring agent to enter security against the assets of a company that's pledged against those loans, or is being advanced as a guarantor against those loans, if that is required in the future. It's a totally conventional restructuring step. It doesn't in any way suggest that there is in fact a mortgage. And when you read that statement, I can understand why my learned friend got misunderstood it, but it doesn't say what he thinks it says. It doesn't say that there's a mortgage. And this is genuinely the first time anybody, including Abu Dhabi Commercial Bank, has ever suggested that there is a mortgage in their favour over this property of any sort. And I believe you can see the final communication between the final communication between the respondent and Abu Dhabi Commercial Bank. If you can find it in bundle 2, tab 3, page 1137. The reason why Abu Dhabi Commercial Bank was told about it, and this emerges from the contractual documents, is that before enforcing security, there's an obligation to consult with the restructuring agent, which is Abu Dhabi Commercial Bank. And then the Abu Dhabi Commercial Bank will consult with the other lenders. And you'll see it's all copied into Alan Overy, the lawyers for the other parties. It's not something that's been overlooked. So there's literally no suggestion anywhere that there is in fact this mortgage. And then you've got this question, well, all right, imagine that there was a mortgage. What difference does that make? And my own friend says, oh, well, even if there's a mortgage, it has an interest. But what he doesn't do is take you to any of the provisions of the real property law, which show that absent a registered interest, there is no interest. And in particular, he doesn't draw your attention to the provisions of the real property law which say that a mortgage is created by registration within the meaning of the Act. Or the general rule at Article 26 of the real property law that states that no interest in land is created unless it is registered. He doesn't refer, Your Honours, to the recent Veggie Bar case. And you only have to read as far as paragraph 2, where the Chief Justice said the registered owner has an indefeasible title, and where none of the exceptions in Article 33 of the real property law apply, any person claiming unregistered rights or interests will not be able to enjoy them.
Well, but that's as against the registered proprietor, isn't it?
Mm.
I mean, it's
because that's about the in rem rights, so that's going to be as against the world.
Yes.
As against the registered proprietor, they may well have an argument,
yes.
because they'll have a contract. But as against the world,
Then,
unless it's registered, they've got no interest in the property.
But then in this scenario, though, there's an unregistered mortgage. If there is a contractual interest, well, anyway, I think we're getting ahead of ourselves. I don't know how the torrent system of DIFC works. I don't know how it works in my own jurisdiction, and unregistered securities are commonly recognised. They don't have any registered proprietor has priority over an unregistered proprietor, but the unregistered interest holder nevertheless has an interest. It's just deferred to the registered proprietor. But I haven't looked at the DIFC law, but no doubt if the amendment is allowed, we'll have to go through that.
Well, Your Honour, I can just show you one article of the DIFC real property law if it's helpful to look at that.
Well, I think either we're going to determine it on the merits today, or we're going to determine it on the merits some other time. And I think if we're going to determine on the merits some other time, I think we should defer it until then.
All right. If Your Honour's content to move forward on that basis, then I'm not going to deal with it. But there's this other point about orders nice sign. Your Honour will know that the position in Australia better than I do, and I'm not in a position to give you a broad view of it. But my understanding in Australia is that orders for foreclosure is ultimately, in most states in the Federation, is an out-of-court remedy. So it's a self-help remedy. And if you look at the legislation in the states where it is available, there's no reference to orders nisi. What you do is you look backwards. You look backwards to see the question of whether or not the party has had sufficient notice. But again, all of that, if this is allowed to go forward, we're going to have to adjourn off. We're going to have to have another hearing, which will be, no doubt, many weeks in the future, because we already know Mr. Flynn's not available in the window that the court was given. And we're going to have to come back and argue all that before you. So effectively, you're being presented with a fait accompli. And the same is true about the other issue, which is this question of whether or not excuse me, lost my place. The other point is that my learned friend's chief complaint here is that there was no order nisi, but in effect the order replicated an order nisi with a relatively short period to allow them to come up with the money. And what's effectively being said is, well, they should have had 6 months. So 6 months from the hearing, at least, would have taken them to the 5th of November. And it's not correct to say that anyone has produced the cash. If they were saying, look, we'll pay us the money into court, and that came within 6 months, it might well have been open to them to say, well, all right, we should have been given 6 months before this was made absolute. We put the money into court before that 6 months expired, and then we can have an argument about whether 6 months really should have been provided as a time period. But what we are is we're well past that point now. We're more than 6 months after the hearing, and no money is being provided. And the offer that has been made and has been referred to is not an offer to produce the money now. It's an offer to produce the money in several months in the future on the sale of the property, if and when that happens. So the question there is, well, look, assume that he even if he wins on this point, what difference does it make to the outcome? And that is clearly, on the facts that we now know, assume we're allowed to take into account all of that information. It doesn't lead anywhere. And then there's this point about not allowing Ms. Elzevir.
As the way things panned out, as of June, there was an order for foreclosure, and Mr. Flynn's client hasn't been the registered proprietor of the land since then.
Yes.
But if there'd been an order nisi, so there hadn't actually been foreclosure and a capacity to sell, then that might have made the sale a lot easier, mightn't it?
I don't think it's being suggested that it's been hard to get money together as a result of this. In fact, what's being suggested is that the money is available or will be available at some point in the future, quite apart from the orders that's been made.
All right.
Let's assuming that Mr. Flynn's client is prepared to put amount of cash that he's now owing to your client on the table. I'm sure your client would agree to settle this matter, would she?
I've got no instructions, and if that offer is made, genuinely, if money is actually produced and available, then I'm sure that will be considered. But the point here is that what my client has seen is years of
I understand. I understand what you mean. I'm just saying that to give the last chance to Mr. Flynn's client, that he was so just now he was mentioning that there was somebody who was interested to purchase his property. So I think, as Justice Martin mentioned, is it fair to for your client, Mr. Montague, to have sort of a profit on your mortgage because the value of property has gone up now?
But that is simply not accepted. So there's two parts to this, which is what's the evidence of the value now? Can you introduce that fresh evidence? But assume that against me. Assume you can introduce the fresh evidence of and I don't accept that you can. If you actually look at the evidence that's been produced, that evidence says this is not a valuation. This is not a property that anyone is going to want to buy in its current state because of the zoning of the land, and it suggests that is changed to make the land more available. So I don't accept that the value of the land will be greater than, firstly, the principal amount that's due, secondly, the interest that is already due, thirdly, the interest that would have accrued by the time of the sale, which could well be in years' time, even if there are suggestions still now that it'll be soon. And then fourthly, you may recall...
It was just crossed my mind whether we could... I'm always suggesting to parties to find a solution for settlement rather than... I'm known for doing that all the time.
Yes,
so nevertheless, that's... Have you got anything else to say, Mr. Montague? Have you covered your reply to Mr. Flynn?
Well, nearly.
At every point?
The final point that I wanted to make was this, that somehow it's being suggested that there's some great unfairness because the appellant wasn't allowed, the way it was put was, the appellant wasn't allowed to get legal representation. The appellant had 6 weeks and said said in her subsequent evidence that the appellant had only had, I think they said 8 days or about a week's notice of the hearing. In fact, what Ms. Al-Jabir said at the hearing was that notification of the hearing arrived in the last week of Ramadan. Ramadan ended on the 23rd of May, which meant that the likelihood is, you will recall there was this issue about whether or not an email went out from the court on the 20th and whether it was copied to the respondent. She now says she didn't receive that, but at the hearing she'd said, well, actually we received notice in the last week of Ramadan, which would put it around the 20th of May, not the 28th of May, as she now says. But in any event, it's not for lawyers to tell you what your defences are. Is there any defence to the claim? Is there any actual defence to the proposition that the respondent was in breach and in default, the appellant was in default of the loan arrangements? There's been various suggestions that there's some quibble about the interest that's been raised. No explanation has been said as to what that is. But no one has ever once said that they weren't in default, that they didn't have to pay this money back. And therefore that an order for an order for foreclosure wasn't therefore appropriate. So, Your Honour, you've heard what I have to say, and as I say, there really is no prospect of dealing with this appeal in this way today. So the question is, do you simply accede to a litigant's application in effect to force an adjournment, or do you hold them to the documents which were prepared by QC on their behalf 6 months ago, and require them just to get on and pursue the appeal grounds that they advanced previously? While, as I say, they are pursuing a competing case in the Dubai courts.
Are you saying, I know that you mentioned this before, but remind me, are you saying that the case in the Dubai court is what exactly what they filed here?
So they filed a claim, an application in the Dubai courts to appoint an expert to determine how much interest is due under the loan agreement. That is said not to be in any way a breach of the arbitration agreement, because it's said to be an attempt to get evidence for arbitration. But either way, it is to be a collateral attack on the orders that have already been made by this court, because there's no need to get an order or have any kind of proceedings to determine the amount of interest if there's foreclosure, because the effect of foreclosure is to cancel the loan. And that's really the point there. Ultimately, we have taken no action in relation to it because of this appeal. Hopefully, if and when this appeal is dismissed, then the appellant will be persuaded to withdraw its Dubai court proceedings. It should at least have suspended them, but it hasn't. It's still pushing them forward. And if that doesn't happen, then of course we'd have to come back to Your Honours for an anti-suit injunction. I understand that the judgment is due on the 24th of November, I'm told, in the Dubai court proceedings. Presumably judgment would be to appoint an expert, but I don't know. I don't have further details.
Okay.
You can see the strategy. Push it back. Let's get a foothold in the Dubai courts. Get a judicially appointed expert to determine some aspect of this dispute, and then they'll be better placed to spoil the action in the DIFC.
And then take it up to the JJC.
And then take it up to the JJC. They haven't yet done that. They haven't yet done that, but we wait to see.
Okay, Mr. Flynn, you want to reply on this point? Just the point raised by Mr. Montague.
I do, Chief Justice. I think the first point is the one that you made, Chief Justice, which is surely Emirates would want to settle this matter. And one of with respect to Mr. Montague-Smith, he has strayed into the merits. I suggested that I deal with the merits so that you could deal with the application. But in fact, I took it shortly and just dealt with the application itself, and a lot has been said about the merits.
I noticed Mr. Montague has gone into the side, but doesn't matter. I think he did it in response to us, to the bench. That's why he raised it.
Well, let's start with the settlement point. I told you that there was an offer to pay out Emirates Bank. Nothing was said about that in terms of why that offer is unacceptable. So although my learned friend says it's all about my clients delaying, I completely reject that. Firstly, no explanation has been given as to why the offer is unacceptable. It's an offer to pay out Emirates, all interest, all capital, everything due. Nothing is said about that.
Is this the official offer?
It's not
no strings attached.
It's not a cash offer. It shouldn't be presented as a cash offer. It's simply not. It's an offer to pay in the future.
Yeah, that's what I'm saying. Is it a cash offer or is it an offer to pay in the future?
It's an offer which gives a deposit of 5 million AED, and as part of the offer, on the sale, Emirates gets paid out. That's the point. Now,
Yeah, but when is the sale going to take place?
well, remember, I think it's important to remember that what Justice Giles was told is that no sale was possible within 18 months. In my submission, it will be a sale that will take place far quicker than the 18 months that the court was told would be necessary to sell the plot.
Well,
So-
why does it take 18? Why does it take 18 months? I'm not familiar with the practice of land sales in Dubai. Why does it take 18 months? Can you?
That was what Emirates told Justice Giles was the period in which it would be necessary to make the sale. That was what they told him. So that was their own evidence before the judge. That was what they were saying to the court.
So you are now saying that the purchaser now says, I'll pay cash 5 million dirhams. Is it USD or dirhams? And the balance of how much? What is the balance?
Let me tell you what it says. I don't think the offer letter's in the bundle, but I can tell you what it says. It says,
read the letter to us.
Yeah. Subject to contract and to your full consent to the transaction, we are willing to make an offer to the bank as follows. Upon and subject to successful completion of the transaction, we'll direct payment of that part of the purchase price to clear A, monies owed to you by Al Rihab as previously secured on the plot, which we understand was about 97 million dirham on the 30th of October 2020, plus the interest accrued to date on completion of the transaction at a daily rate to be confirmed and agreed between us, the cost incurred by you in the foreclosure court action and the amount expended to date, are defined as the bank liabilities. A deposit will be paid to you of 5 million dirham, including 1.5 or so already paid into court. This deposit will be on account of the discharge of the bank liabilities on successful completion of the transaction. The deposit will be fully refundable if you fail to consent to the transaction or the transaction doesn't complete for any reason. Completion of the transaction is subject to our due diligence.
But to be fair to Mr. Montague-Smith, the beginning of the letter is the tricky part. Read the first part of the letter again.
Yes, subject to contract and your full consent to the transaction, we're willing to make an offer to the bank as follows. 1, upon and subject to successful completion of the transaction, you'll direct...
That's the trick. Subject upon completion. If one party says no or disagree with a term of the contract, the deal is off.
Sure.
Then what Mr. Montague-Smith is saying, you will drag that for another few years. That's what he's saying.
But except that as matters stand, he's got an order for foreclosure that makes Emirates the owner of the plot. So I think I could put it this way. There's more to this than meets the eye. It's not as straightforward as the court's being told. So we have this offer. In my submission, there's no real answer to it. It's an offer to pay out Emirates. It's offered to pay.
You're saying that the land is already in the Emirates' hands anyway. So
Yes.
there's nothing to lose. There's nothing to lose to enter to this agreement because.
Yes, exactly. So the second
Does
point.
the offer, Mr. Flynn, does the offer identify the purchase price?
No, it doesn't.
Well, that's a bit curious, isn't it?
That's why the first part, subject to certain conditions and conditions and conditions, that's where the problem is.
Yeah. But the point here is that what we're dealing with is a foreclosure order in which a lender obtains titles. So that's the issue. And a lender doesn't normally have any interest beyond that which the sum of money that's owed to it. And this is an offer to pay out that sum of money. The second point that my learned friend made was he essentially, and I think it's picking up a point that Justice Martin said, which is they really brought this upon themselves. They applied very late to the court. They left very little time. They didn't give notice of foreclosure. They simply gave notice of enforcement to third parties. And they now say, oh, well, none of that matters. They brought this upon themselves. And my learned friend is trying to say that there's no mortgage with a Abu Dhabi commercial bank. Now, there was more than enough material before the judge to show that there was, that ADCB did have an interest in the property. And I can take you through it if you would like me to, but that is a matter for debate in due course in my submission. There was more than enough, and the judge didn't take that into... Yeah.
Well, sorry, but it's going to be contested. So the question, I suppose, is whether you want to put on any additional evidence. You'd have to apply for leave, of course. But it's put against you that there isn't enough evidence. So if you're happy to stand on or fall on whether there is enough evidence of that, then that would be the case. But as I understand it, the evidence to which you refer would be the restructuring facility back in whenever it was, 2014 or 15. And that wouldn't establish whether there was a mortgage in place in June 2020, would it?
No, well, put it this way. If there was a mortgage, the priority deed refers to the second mortgage as the mortgage granted over the property by the security provider. And our case will be... You want us to uphold the appeal on the ground that there was a secured creditor who had to be joined and who wasn't. Well, if you want to get the appeal upheld on that ground, won't you have to establish as a fact that there was a secured creditor in June of this year? And I don't think the documents that you're referring to will establish that, will they? I would put it the other way, Justice Martin, which is this. There was more than enough material, at the very least, to raise that issue so that no foreclosure order absolute should have been given without giving the opportunity to Abu Dhabi Commercial Bank to make submissions to the court. In other words, there was more than enough to show that. Now, on our submission, we'll say there was more than enough to show on the basis of what was before the judge that there was in fact a mortgage, albeit unregistered, and that therefore the Abu Dhabi Commercial Bank's interests should have been taken into account, and they weren't. I don't, in my submission, have to establish that there was in fact such a mortgage, although we do say that there was sufficient material before the judge to determine that. And indeed he found as a finding that there was consent to the mortgage, and there were other documents before the court that showed that a mortgage was entered into. So in our submission, what was wrong was to proceed on the basis that one could simply not have any regard to that at all and just make the order absolute there and then. It was certainly, at the very least, there was a question mark over it, and on our submission, there was sufficient evidence to show that there was a mortgage, and therefore they had to join Abu Dhabi Commercial Bank.
Well, but of course, if your client had been heard, and you say they should have been heard, then they would have had to tell the court whether there was in fact a secured creditor or not. And the position you've just enunciated is, well, you say, well, we don't have to tell the court whether there's a secured creditor or not. We just point to the fact that there is material that suggests there might be a secured creditor. Now, I'm not sure if you're going to be a bit. I understand your position, but I just warn you that looks a bit coy to me. But anyway,
I understand that, and the court, of course, may be assisted by the provision of the mortgage. I can see that.
Indeed.
I totally see that. The point, I think, for present purposes is this. What is being said against me is that you should shut out these submissions on the basis that they're being made late. And in my submission, that's no answer to the interests of a third party here. That's different to the question of substance. I think in my submission, from the debate that there has been, it's absolutely plain that there is a case which is worthy of argument. There's no doubt about that in my submission. So there is no basis for opposing the amendments on the basis that it doesn't raise an arguable case. It clearly, in my submission, does do that. And I take on board what you said, Justice Martin, about the point that if the course had been adopted that we say should have been adopted, then there may well have been additional evidence, and this court may benefit from that additional evidence. I totally accept that.
But the same point applies, Mr. Flynn. If you're going to make something of this offer, then again, obviously you'd need to put that into evidence. You'd have to apply for leave to adduce fresh evidence and put it in, and we'd want full disclosure. A letter to the bank which is coy about the purchase price would make me very curious, I have to say.
Yes, and I think it's right that you should have that. because that is obviously something that's only happened in the very recent past, and you should see that, because insofar as it's suggested, and it was suggested today, that the Emirates Bank's only interest is in the proceeds as opposed to the equity of redemption, it's important that the court does have the context of the offer to see whether the rejection or failure to consent to it is in fact consistent with that submission. I do accept that. I do accept that. Then there is the other point, which is it's put on the basis that we are the party delaying. We want the delay. But in fact, we're not asking for delay today. We're perfectly happy to go ahead. It was my own friend who asked for time, and I accepted that if he says he needs time, I can't countermand that. If he wants time to address the submission, so be it. But we could have proceeded today. These are points of law that he reduced all the authorities on this issue, which actually straddle the question of substance. And we could have gone ahead today and we could have dealt with the matter. We're not asking for delay. We're saying that we don't oppose his request for delay, not ours. So it's not right to suggest that we are the ones just seeking to drag our feet. It's quite the opposite as matters stand today. And then I gratefully adopt Justice Martin's analysis of the cases. The cases that have been adduced in evidence are cases where some but not all the submissions have been made and the court is reluctant to allow further submissions on the appeal. The whole point about this case is that it was rejected in a peremptory way in which my clients didn't get the opportunity to appoint legal representatives. And as I say, that was in the context of the bank applying at a very late stage. This is a very different situation here, where you have the interests of my clients not being able to appoint lawyers, the bank applying very late, and the interests of third parties on a point of some considerable general importance. So in my submission, all of those factors go to allowing the amendments to be made. And as I accept, we're not asking for delay. We're accepting that if Mr. Montague-Smith wants delay, then he can have it, and we're in his hands as to how long that delay is going to be. So we're not.
But Mr. Flynn, we were told by Mr. Montague-Smith that your diary is already very full, and your next date may be very long to go. That's what he was trying to say.
No,
are you free? Are you? Can you give a date, which is, whatever date is within the next couple of weeks or so? Are you free to go ahead?
Yes, and I don't know where that's come from, because at one stage I was asked whether I could do for this hearing the Sunday the 6th of December, and that is correct. In fact, if the hearing is on a Sunday, I can do it before the end of the year. It's not
Sunday.
My availability that's causing the issue.
Any Sunday is suitable to you. That's what you're saying.
Well, yeah, as long as it's I think up to the 20th, but not beyond. But yes, within reason, absolutely. It's not.
Well, you're going for Christmas. There's no Christmas celebration in England this year, So,
yeah, and it's been ruined.
Don't
it's been ruined enough. So no, and it's not. I'm not suggesting that if we get the delay, which has been requested, that it will cause a substantial further delay. I don't agree. As long as provided Mr. Montague-Smith can put in his written submissions within fairly short order, we can have another hearing probably before the end of the year, if the court can do that.
Okay. Is that it?
Yes, unless you have any questions.
Okay. Is there any question from you, Judge Ali and Justice Martin?
Yeah, sorry, I think Mr. Montague-Smith wants to say something.
Can I just make one suggestion, which is this? If you are concerned, if the number of points are raised, if you have a concern about the position of Abu Dhabi Commercial Bank, you will be aware Abu Dhabi Commercial Bank was aware of the proceedings and so on. But if that is what is causing you concern, then my short proposal would simply be that we, that is the respondent, write to Abu Dhabi Commercial Bank and see if we can get their input as to whether they have a mortgage and whether they wish to participate in these proceedings. If they write back to say they don't, well, that, it seems to me, on either front, must be the end of the matter. And the other point is, if your concern, if your thinking is tending towards some sort of adjournment, then it just has to be on terms that the Dubai court proceedings will not be pursued and will be suspended.
Why? Why would we interfere with proceedings in Dubai?
Well, because otherwise, you're not interfering with proceedings in Dubai. You're being put in a position where you have to adjourn this hearing, and it said it's my fault. It's not. It's because a whole load of submissions have been filed 2 days before the hearing. But if you do adjourn this hearing, then that has an effect on the interrelationship between the two sets of proceedings, and so it would be right in those circumstances to require the appellant not to try to run two horses at once. That's a classic case of abuse.
The appellant's been running two horses at once for the last 6 months or however long. I don't understand why an adjournment for a couple of weeks would change that situation.
Well, as we hear, I understand the judgment's due to come out in the next few days.
And the judgment will be for the appointment of an expert who will take months, presumably, to do his business.
Well, I don't know, but that we'll have to keep going down that route. So it's a classic case of abuse when you're running two sets of proceedings at the same time.
Well.
All right.
Okay.
Well, anyway, those are the point.
Okay, we'll take a break. Say what? Half an hour break, 45 minutes break, and then we'll come back to you, Mr. Montague Smith and Mr. Vernon Flynn.
I'm so sorry. I've been told that I've been given more information about what's going on shore. The expert has been appointed, and it's to finalise, I think, his position.
Okay. Okay, so we take a break, short break now. I'll come back again to you all, give our decisions.
Sorry, I missed the time, sorry.
Let's say about half an hour, 30 minutes.
Yes, thank you.
Okay, thank you. So all the parties are around. Okay, we have given a careful consideration to the application before us, and for which we have heard both counsel who has made very good submissions. Our decision and orders are as follows. We have decided to allow the amendments. Please correct me if I miss something, just this Wayne and Judge Ali. If you are to adduce any evidence, then you are required to do so within the next 2 weeks. 2 weeks. 2 weeks.
Any application for leave to adduce evidence has to be made within 2 weeks.
Application to adduce evidence. What if the... Yes, figure them. Can we give a date to that rather than say 1 week? Can we give a date?
Well, would be 2 weeks from now. Would be the 6th of December.
On or before 6th of December. And then the respondent is given another 2 weeks from there, which is the 20th of December, to file their response.
That's the skeleton.
Skeleton submission to respond. And then hearing, let's look at hearing dates in January. Can we have a look at date for hearing in January? Anything from 4th, 5th, 6th, 7th, 4th, 5th, 6th, 7th of January? For the benefit of Justice Martin and both of you, I want to avoid Sunday if possible. It's okay with me. I can work on Sunday and Justice Ali works on Sunday, but for your benefit, if we can avoid Sunday.
It's just Sunday the 3rd, CJ. I've got a problem. I thought you said, CJ, you've got a problem on the 4th of January, haven't you?
Yes, 4th I can't. I have a JJC meeting with Dubai on the 4th.
So I don't know,
That's
5 or
not
6
set
January. I don't know how that suits council.
6th January,
Or 5.
5th or
Is the
6th or
7th
7th.
not, is the 7th not possible? I think that would be my
7th?
preference.
7th would be all right.
I can do 5, but 7 would be my preference.
7, Mr.
5
Flint?
or 7th.
I can do either,
Mr. Philip?
so I'm happy. I can do that. I can do either 5th or the 7th.
7th.
So the choose. So Justice Martin, which one would you rather have?
Well, 7. If the 7th is better for Mr. Montague Smith, let's go with the 7th.
Okay,
Okay,
let's go
fine.
to the 7th. So 7th, what time? What time? 10 a.m. 10 a.m.
3 a.m.
Or 10:30.
Why not?
10:30. I mean,
Yes. I mean, obviously,
you have to be fair to Mr. Justice Martin and myself.
Yeah.
We are
Yes.
already 4 p.m. here
Yes.
because the other day
Well,
when
what's
Judge
that, 10:30? 10:30 in
10:30.
Dubai?
10:30.
Yep.
10:30 a.m. which is what time is our time? 4:30. Is that right? 2:30.
That'll be 2:30, CJ.
2:30 Malaysian time. And London, what would they be?
It will be
That'll
6:30.
be 6:30.
Wow, I'm sorry for you. Anyway, it's not a Sunday, so you should be quite happy with that. So as costs thrown away to the respondent, amount to be determined by the registrar unless agreed upon. Okay, is there
Yes,
anything left that I missed?
Appellant to pay the respondent's costs thrown away. Yes, thank you.
Yes. I don't know, cost thrown away, cost in any event, whatever it is you call it. Okay. So if there's nothing else, thank you very much to everybody. Thank you very much, judges. Justice
Thank
Martin,
you. Thank you, everybody.
Judge Ali.
Thank you.
Thank you very much.
Bye.
Thank you very much all.
Thank you.